All right. Good morning, everybody. I'm Whitney Diver McAvoy, President and CEO of the Yountville Chamber of Commerce. Welcome to our February 2024 webinar series about the 2024 labor laws. We're thrilled to welcome Marissa Buck with Dickinson, Peatman, and Fogarty here today. She is a partner in their employment practice group, and she's going to give us an overview of all the new labor laws that are important to us here in California. Feel free to drop your questions into the chat as we progress through this presentation. We'll also have some time for questions at the end as well, but we're happy to take questions throughout the presentations because we're going to be going over a variety of different topics today. Okay, without further ado, Marissa, I'll let you take it away, and thank you so much for joining us today.
Great. Thank you, Whitney. Appreciate the intro. I'm Marissa Buck. I work at DP&F. Our name's a little bit of a mouthful, so you can use the shortened version. I am in both the Napa and Santa Rosa office, and we help clients all across Napa Valley and Sonoma County too. So we do a lot of these updates this time of year. So we will go ahead and get started. I'm going to screen share for everyone. So this is our employment law update for 2024. See if it'll change that. There we go. So just some quick disclaimers. I am an attorney, but this presentation is not intended as legal advice, and attending this session or answering questions during the session doesn't create an attorney-client relationship between me and anyone else in this call or DP&F. This is just for informational purposes. If you have questions that come up after this that we can't answer, though, you can reach out to us or your legal counsel to follow up, but most questions I'll be able to answer. Humor, just a little disclaimer, if to the extent there's humor used or attempted in this presentation, it's not intended to offend anyone or indicate that we take the topics lightly. Obviously, your legal compliance is serious, but that doesn't mean it has to be boring. So that's my personal take on it. So here's our agenda for today. There are a relatively large amount of updates for this year, but we've compressed it as much as we can to get your time's worth in this hour. So we'll start by talking about minimum wage because that is always the most important. So I always put it first. Then we'll go through quite a few new laws for 2024, just so you're aware, and in sort of in order from most important to least important, we do our best. We'll do a quick discussion on a couple cases that came out last year, a court case and a decision from the National Labor Relations Board that affect employers. And then we'll do some reminders, because I like to throw in the reminders of all the existing things that you all have to comply with, and a little bit of a COVID update since they did change those rules. And yes, they're still hanging around this year. I know it's exhausting to talk about it still, but we will cover that. And then, like we said, we can do questions at the end, but feel free to ask questions throughout as we're on a topic, because it's often easier to just answer them as they come up. And Whitney will navigate the chat for me while I talk. So if anything comes up, we'll jump in. So let's get started by talking about the minimum wage increase for 2024. You're probably aware that the minimum wage has been going up every year for the last, it's been about 8 years now. And so now we're at the point where it'll be a decision by the governor each year how much we will raise the minimum wage, and it's based on the CPI from the current year that we're in. So the maximum they can ever increase it is 3.5% from the previous year. So this year they raised it the full amount that they could. So it went all the way up to $16 an hour. That's for every employer in the state, regardless of how many employees you have. So $16 an hour is the minimum wage. Now, there are local ordinances that have higher minimum wages. Napa County, nowhere Napa County does. They follow the state. If you do have employees in some places in Sonoma County, there are some areas that have a higher minimum wage. So a good example is the city of Santa Rosa. Our minimum wage here in the city is $17.45 an hour. So if you have employees generally that work 2 or more hours a week in a different location, you should double check that there's no higher local minimum wage. Otherwise, you're at $16 an hour. You should have your minimum wage poster somewhere where employees will see it, usually like a break room or some gathering spot. So that needs to be updated along with the other labor posters for 2024. If you subscribe to Cal Chambers, that's a good way. You can just get your new posters every year. That's the best way to do it because it's hard, just a pain to go print them all and remember it. So if you subscribe, you can just get your updates every year. So along with the minimum wage increase, that means that the salary minimum for your exempt employees also goes up. So for exempt employees in California, you have to be paid at least 2 times the state minimum wage in order to be exempt. So by law, if you pay someone less than 2 times the state minimum wage, they are by law not exempt, even if they meet all the other requirements. So it's really important to make sure you have that salary at the correct amount. So this year, the minimum salary will be $66,560 a year, and that's for your exempt employees. And you calculate that by doing 40 hours a week at $16 an hour, and that's 2,080 hours a year. So that's how they get that number. So starting January 1st, so we're now in February, so you want to go back and check and make sure your exempt employees are meeting that minimum or higher. Otherwise, they are by law not exempt. This salary is the same for everyone, so it's not tied to those local minimum wages, so you don't have to worry about that. It is just the one number for everyone. And it's something to keep an eye on if you have salaried employees that are real close to the minimum, because each year that we see an increase in the state minimum wage, you're going to see an increase in the salary. So it's something to keep an eye on if you have people close to that number. All right, so we're going to talk about the new laws for 2024. You've probably heard about this one, the increase in the paid sick leave. We'll talk about that first because that's a big one. There is a new reproductive loss leave that's required for all employers with 5 or more employees. We're also going to talk about some additions to the cannabis discrimination law, which came out last year, but they have made a few changes and it actually went into effect this year. We will talk about the new presumption of retaliation rule, briefly go over the non-compete agreements, although most of that everyone's probably good on, but we'll touch on it. And then the workplace violence prevention requirement, which is coming up on July 1st. So let's start with the increase in paid sick leave. So starting January 1st, 2024, the amount of paid sick leave that you have to provide to employees has increased to 5 days or 40 hours per year. So it used to be 3 days or 24 hours. It's now increased to a full week. So 5 days or 40 hours a year. Everything else in the law, for the most part, stayed the same. So if you use an accrual method for your sick leave, the accrual rate is the same. It's still 1 hour for every 30 hours worked. So that has not changed. If you do an alternate accrual method, which we generally don't recommend, but if you do it, if you have a reason to do it, you have to make sure now that they have enough sick leave available. They have to have 24 hours available by the time they hit their 120th day of employment and 40 hours by the time they get to their 200th day. But that's only if you use an alternate accrual method. So if you stick with the 1 hour for every 30 hours worked, you're good. You don't have to worry about that 120th day, 200th day. So we recommend it because it's just easier. If you do the accrual, they do have to be allowed to accrue up to at least 10 days or 80 hours, but you can still limit their use to 40 hours a year. So the way the sick leave statute is written, they distinguish between accruing and use. So while they're allowed to accrue, you can still limit their use to the 40 hours in a year, which yes means in theory they never use those extra hours and they don't get paid out on termination. So there's not a big it's not a big risk or liability there for employers. You can also still do a lump sum if that's how you like to do it for your policy, which means you can give them 5 days at the start of the year or on their anniversary date or whenever the start of your year is, as long as it's a 12-month period. If you use PTO, so paid time off, where it's one bucket where you have vacation and sick leave and they're allowed to use their PTO for both, make sure that your lowest PTO accrual rate complies with the new requirements. So if people who have worked for a year or 2 years don't get 5 days of PTO, they're lower than that, you'll need to bump that up or add some sick leave in a separate policy. So just make sure everything's compliant. The reproductive loss leave is a new leave that started this year on January 1st. This applies to all employers if you have at least 5 or more employees because it's under the Fair Employment and Housing Act, or FEHA. So this is an unpaid leave. It's 5 days of unpaid protective leave for certain reproductive loss events. It applies to all of your employees who have worked for you for at least 30 days. They don't have to take the 5 days consecutively, but they do have to complete it within 3 months of when the event occurs. The leave is available for every qualifying event, but you can limit the maximum amount to no more than 20 days in a 12-month period to put a cap on it. I don't suspect this will be one that people will really abuse, but they always put some sort of limit in the statute just to prevent that. The definition of reproductive loss event is broad. It includes failed adoptions, failed surrogacies, miscarriages, stillbirths, unsuccessful assisted reproduction. So it's quite broad. Obviously, you don't need to know specifics, and you shouldn't ask specifics from your employees. There's no provision in here for a doctor's note or any medical certification. So this is one of the ones where in most cases you would take your employees' word for it. And I, again, don't expect this to be one that people will really abuse given what it is for. So I wouldn't be too worried about that, but don't put something in your policy that says they have to provide a doctor's note, since that's not actually provided for in the statute. And the leave does apply to, could apply to multiple employees that are affected. So the spouse, the domestic partner, or any individual that would have been the parent of the child. So you could have multiple people. I put in oh, go ahead.
Sorry to interrupt, Marissa. We've got a question on the sick leave. So does the sick pay labor code apply to all companies, or is there a minimum employee count required?
It does apply to all employers regardless of size. So the Healthy Workplaces, Healthy Families Act applies to all employers. So this will be for everyone. That's a good question, because a lot of these, we've got a lot of different limits depending on what law we're talking about. I put in a bereavement leave reminder because when we were going over the reproductive loss leave, it's very similar to the bereavement leave statute, and the bereavement leave was just added last year. So I just put this in here to clarify that they are separate statutes and separate entitlements. And if you missed it last year and you haven't updated your bereavement leave policy, you do need to update that to make sure you're providing 5 days of unpaid protected leave for bereavement purposes for the death of a family member. The family member under this statute is the same as under your SIFRA, so your family and medical leave. It's that same definition of family member. You can do more than that if you want to, but that's the minimum. And these are distinct 2 different leaves. All right, so we're going to switch gears a little bit and talk about the cannabis discrimination law. So starting this year, this law was passed 2 years ago, didn't go into effect until this year. They added a protected class of off-duty cannabis use to the Fair Employment and Housing Act. So most of you probably have a discrimination policy in your handbooks, and it has a long list of protected categories. This will be added to that list. So it prohibits discrimination against employees for off-duty cannabis use, as well as a drug test that's positive for non-psychoactive cannabis metabolites. So all that means is that when you test for cannabis, it's detecting whether there's cannabis in the system, but it doesn't test for current impairment. So if you've used cannabis within the last 2 weeks, a month, it will probably still show up on a drug test because it's in the person's system, but that does not mean that you can determine, that you can't look at that test and say, oh, I know exactly when you were using cannabis and when you're under the influence. It doesn't tell you that. We don't have that ability yet. So you can't use a drug test to discriminate against an employee because it doesn't give you the information, and they could have used it while they were off duty, which is fine because they weren't at work. And so you can't discriminate against them for that. You can still prohibit on-duty possession, being under the influence while on duty, or using while on duty, just like you can still prohibit on-duty use of alcohol, right? You would probably have a drug and alcohol policy in your handbook that says, hey, you can't drink while you're on the job. That is the same for any other drug, including cannabis. So that you can still prohibit, not allow, that is all okay. You can still do a drug test technically, but you're not gonna be able to do anything with it because we don't have the ability to do a test for current impairment. So for alcohol, you could test someone to see if they are currently under the influence of alcohol, and you could see what their blood alcohol content is, right? We don't have that for cannabis. So because you can't use the test that we do have, there's probably no point in testing because I don't know what you're going to do with it. So it sort of just removes the need for that. If we do invent some sort of test that would show current impairment in the future, that would be okay to use under this law, the way it's drafted. It just doesn't exist yet. There are also some exceptions to this law. So if you have employees in building or construction trades, those are exempt, it doesn't apply. Positions that require federal background checks, this law won't apply to stop that because currently under federal law, it's still illegal, and so they can still require testing for that. So if you have anything where you're not sure whether you're still allowed to, it's good to check because there are some exceptions. So they added to this law this year before it went into effect to also say that it's unlawful for employers to request information from a job applicant relating to their prior use of cannabis. I don't think anyone was doing this anyway, because you shouldn't be in a job application or in an interview, but just a reminder that that wouldn't be a relevant question for a job application. The only exception here would be if somehow it was involved in someone's criminal background check. And for criminal background checks, of course, you still need to be following the requirements to do the background checks properly, have all the proper disclosures, give employees the chance to respond. But let's say they have a felony conviction that's related to the use or sale of cannabis, that could be relevant depending, but there's a lot of factors you have to look at for criminal background checks. You have to look at whether it's related to the job, how long ago it was, all of that. So you're allowed to look at it in that sort of limited circumstance, but you obviously wouldn't just come ask someone, hey, do you use cannabis a lot outside of work? Like that wouldn't be an appropriate question for a job applicant. All right, if there's no questions on that, we'll move on. So the presumption of retaliation.
Oh, sorry.
Oh yeah, go ahead.
Yeah, somebody just popped in. HR support has asked, can you clarify regarding cannabis, if someone shows up to work under the influences, we are still allowed to drug screen or not?
Well, the problem with that is there is no drug screen that would tell you for sure that they're under the influence. I mean, sure, it could tell you that they have cannabis in their system, but they could say, yeah, I smoked this weekend and that's why it's in my system and I'm not high now. Like there's not actually something that would tell you, yes, 100% this person is right now at this level and that means they're high, right? We just don't have what we have with alcohol, which we have a BAC test and we can do that. When you suspect someone's coming to work under the influence, just like with alcohol or any other drug, it's always good to focus on the performance and what's going on with their performance and how they're acting at work. And remember that you're not the police. So you don't have to prove 100% that they're under the influence for there to be some sort of discipline or action against them, right? If they are coming into work and it seems like something's off, you're getting complaints from clients, from customers, from other employees, and they're not doing their job, they're not, doing all of the things they're supposed to do and performing up to the standards, you can still address that with the person, whether or not they were using any substance. Same goes for drug testing for alcohol, because we've seen this happen before. You do the test and then turns out they're actually below the limit or they weren't drinking. And then what do you do? So now you have a clear drug test. It's like, well, but the performance is still an issue, right? That's why you did the test. So it's always, I think, it can be better to focus on performance, and that's true for everything, right? Performance, performance, performance. We say it a lot, but it's true, to focus on what they're doing and what the issues are, as opposed to trying to prove something. You don't have to prove that they've committed a crime or used drugs you're not the police. So it's okay if you can't prove it 100% if there are still obvious issues with their performance.
So Marissa, I'm just going to pop in if you don't mind, since we know it's me that asked the
Yeah.
question.
Of course.
So just kind of to dovetail off of that a little bit. So I come in high as a kite, and you can tell that I am high as a kite, and I may be in a safety sensitive position. Yes, we can focus on the performance and such. Typically based on focusing on performance, we don't send anybody home for just performance. You know, there's a whole process of documentation and let's see what you're doing. But if it's a safety issue and we know clear as a bell that it's because this person's under the influence, I just want to be clear. We can no longer say we have to send you over to our clinic and get you drug tested or anything. We can't. Do we have the ability to send home at this point? Or just, I just want to clarify that piece, because performance documentation for me and something relating to being under the influence at work are two separate things.
Yeah, I think in that case, of course, you could still send them for the testing. It's just not clear that the testing is going to give you much that you don't already know, right? Because you're in this situation, you can tell. You're like, something's off. It could be, who knows what it is, but they're off. And so you could still send them for the testing, because who knows if it's something else, right? But there's a lot of things that could give you a similar issues. And if it's a safety sensitive position, that gives you another reason to send the person home or look into it, because the safety issue now rises, that is rising the level of your obligation. You're now at a different level, because that person could get injured, other employees could get injured, customers could be injured, right? You have more of a reason to really protect them versus if their job is, just not as safe. There couldn't be anything really dangerous that would happen. So I think you can use that too, but you can still do the testing. Just unclear that you could do much if it comes back positive for the non-psychoactive cannabis metabolites, which at current time is all we can test for. So hopefully in the future, if you can test for more, that will be more helpful. I mean, it's funny, the way the law is written, they almost write it as if that test exists. And when we all read it the first time, we're like, what are they talking about? This doesn't exist yet. Like, this is, like a pretend drug test that we don't currently have. So we'll see. Is that helpful? Does that answer your question?
Yeah, super helpful. Thank you.
And also, of course, if you have these specific situations come up, we always advise talking to legal counsel, or if you have an HR consultant you work with, because they are delicate situations. And a lot of these situations, you may get employees who say they have a medical reason for it or a doctor's note, which is, again, still not determinative and still doesn't mean they can be allowed to do it on the job, especially if there's safety issues related to the job. But it will require some conversations with that employee, and it can be delicate. All right, so this is just sort of a small one that I'm not sure how this is going to come up, but we'll see how it goes, because it's new. But starting this year, they added a new presumption of retaliation under the labor code. So under this new rule, if you as an employer take any adverse action against an employee, so that's, a discipline, a write-up, sending them home for something, firing them, any adverse action, if that action is taken within 90 days of the employee engaging in a protected activity, it creates a rebuttable presumption of retaliation. So that means that it'll be assumed that your action was retaliation, and you as the employer will now have the duty to rebut that presumption and say, no, it wasn't retaliation. Here's the reason we did it. So you already have this obligation with like paid sick leave. So if paid sick leave, there's a retaliation presumption within 90 days of anyone using their protected sick leave. It exists with your paid family leave and pregnancy disability. There's a lot. It exists with workers' comp. There's all kinds of laws where this already applies. This just makes it a little more broad, because the protected activity is defined fairly broadly, and it includes employees making an internal complaint about working conditions, wages, harassment, someone who files a suit against you, which is a little more obvious, or someone who testifies against you. But the one that makes it really broad is the internal complaints. So if they've made any sort of internal complaint about their wages, the conditions at work, your COVID policies, harassment from a coworker, and then something happens within 90 days of that complaint, and you have to give them a write-up, or they end up getting fired, it'll be presumed that it was retaliation for that activity, and you will need to show that it was not. So this is just a reminder for everyone that documenting is so important, and documentation in real time doesn't necessarily have to be like this very formal, form signed by everyone. As long as you have some documentation that's at the time it happened, preferably with one or more witnesses. So when you're meeting with employees, it's always great to have 2 of you present at least. So you've got some witnesses and documentation, and focusing on performance, because that will help you the most. This is pretty broad. I don't know what the impetus was of them passing this, but we will see. I haven't seen it come up yet, but we're only, 2 months into the year. Non-compete agreements. So non-competes, post-employment non-compete agreements with your employees have been void and unenforceable for quite some time. So most people do not have these because this has been the law for over a decade now. But for whatever reason, the legislature was really focused on it last year and decided to put in place 2 new laws that just sort of confirm the existing law. So the first one is that you cannot have unlawful non-compete agreements in any of your employment contracts. If you do have those, you are required to give employees notice by no later than February 14th. But if you haven't done it, you can still do it. And just tell them that those clauses or those agreements are no longer enforceable. So you just had to give them notice in writing of that. Most people don't have these. Occasionally we'll see the sort of some bad wording with some higher level employees like CEOs, people who have access to more information or at a higher position. So good to double check. We mostly see it with employers who are based out of state and have California employees, because out of state it may be allowed and so they don't realize it, and then they have it in their agreements here. But most likely you don't have this. And it's not clear from the law. Well, the law doesn't specifically address solicitation provisions. So you may have a non-solicit that says you can't solicit our employees or our clients and customers after you leave. That's still allowed under the law to the extent that they're soliciting using your trade secrets. So like a client list, any other trade secrets you have that they wouldn't have had access to except that they worked for you. So that's still allowable. Some people are taking the cautious approach that this law prevents those. It doesn't say that anywhere. I don't think we're there yet. I do think that will be the next phase of this discussion on non-competes. So just keep an eye out for that issue. The other one just confirms, similar to what I was just saying, that if you're outside California and you try to come into California and enforce an agreement, even if it was entered into outside of California, you still can't enforce it here, which makes sense, right? So that's mostly for out-of-state employers. All right, our last update is the Workplace Violence Prevention Plan. So this doesn't start till July 1st, but I will warn you, that's going to sneak up on you real fast. So all employers are required to establish and maintain a workplace violence prevention plan as part of your existing illness injury prevention plan, your IIPP. As similar to the IIPP log, so just like you keep an injury, and you're going to be required to provide training to employees once you have this plan in place. So you can't just put it in place and not tell anyone. Of course, you need to train everyone on it. A lot of workers' comp carriers will help you with this if they helped you with your IIPP. The state has said they're not going to do a sample plan, like one you can use, but they might still. They have time. People are pressuring them to, so we might see one. I don't have it on here, but there are some exceptions for workplaces that don't need an IIPP, or in this case, the Workplace Violence Prevention Plan. So like if you have employees who work entirely remotely and you don't have a main location, you probably will not be required to have one. If you have less than 10 employees and the establishment's not open to the public, this won't apply. So it's good to look to make sure it applies if you think you might fall into one of the exceptions before you put it in place. Because in general, it's meant for workplaces that would be open to the public that have some workplace violence risk, right? There's a risk that someone could walk in, something could happen, and what do employees do in those situations? It's very specific what you have to do, but it is specific to your workplace. So they're all going to look different depending on the type of workplace you have and how open or not open it is to the public. So just something to keep in mind, get started on it so you don't get to June and panic that you don't have it yet. And then some small additional updates that have come about since January 1st that are just important to know. So the wage theft notice, as we call it, which is the Labor Code section 2810.5 form. You've probably seen it. It's a form where you fill out what people get paid, what their sick leave is, where you're located, and you give that to all your non-exempt employees upon hire. That form has been updated for 2024. So if you're using the old form, you should go in and update that and provide that to your non-exempt employees and then use it going forward. We talked about posters before, so if you get all your posters, you should be good, but the harassment poster from the California Civil Rights Department has also been updated. So if you have an old one, you should get the new one and put that up where employees can see it. And if you use the IRS mileage reimbursement rate to reimburse your employees for use of their personal vehicles, that rate has gone up starting January 1st to 67 cents a mile. So just make sure you're using the right rate for 2024. All right, we'll do a quick discussion of these two cases and what they mean for employers. So we'll start with the California Supreme Court case, Adolph versus Uber Technologies, Inc. This case is about what we call the PAGA law. So PAGA is a Private Attorney General's Act. If you know about it, it's probably because you did deal with one, and I'm sorry that you did because they're terrible. A PAGA action is where employees are allowed to step into the shoes of the labor commissioner and enforce the labor code against a company or an employer. So they put this law in place so that they wouldn't have to use state resources to do it. And they said, hey, we'll let the employees do it. When you recover in a PAGA action, 75% of it goes back to the state and 25% is kept by the employees. So it's not a big money grab for employees, but there is an attorney's fees provision that allows the employees' attorneys to get all of their fees. And that is what drives these cases because the lawyers get paid quite a bit. So if you get a PAGA action, they're a pain to deal with, but it is part of our life currently. The Supreme Court of the United States had limited PAGA actions a bit and said, hey, actually, you could force your employees to arbitrate these actions. And if they don't have individual claims or they lose in their arbitration, then the PAGA action will go away. And we all said, that sounds great. But the California Supreme Court came back and said, no, hold on a second. You can take it to arbitration if you want to, but they'll still have standing to go to court for the PAGA action. So it leaves us in the exact same position we were before. So you can still have an arbitration agreement with your employees. You can still use that to prevent class actions, which is great because class actions are expensive and long and difficult, but it will not necessarily get rid of PAGA actions. There is going to be something on the ballot this year for us all to vote on to change PAGA. So if that does end up on the ballot, you should you should look at it, should see if you're in favor of it and talk about it with people because people outside of employers and lawyers will have no idea what it's about. But the proposed law will take PAGA and put it back into the government's hands. They will say, hey, we're gonna just get some more money to the labor commissioner and they're gonna do it again. And it's gonna be like when you get a wage claim. So they'll file it through the state, it'll be an administrative action. It's not gonna be an individual representative action, which would be fantastic for employers. So we'll see if that actually ends up on the ballot and what comes of that. But it's gotten out of control in the last decade or so. And really the people who are winning are the attorneys. It's not really benefiting the employees like it was supposed to. The other decision we had, which you might have heard about, the National Labor Relations Board issued a decision looking at people's handbook policies and other employment policies and whether or not the policies infringe on employees' rights under the National Labor Relations Act. So you can't have a policy that says, hey, you can't gather with other employees, you can't complain about your wages, you can't complain about working conditions, but everyone knows that. You can't have a policy that prevents that. But what the NLRB said is you also can't have policies that might prevent that. So it may not be clear, but the policy can't discourage them from forming or joining unions, talking to each other and having concerted activity to improve their working conditions, that you can't prevent that with your policies. So it's just made everyone look a little closer at their handbook policies to make sure you're not chilling the employee's exercise of their rights by something that could be interpreted that way. So it's a little gray. We would recommend putting some disclaimers in the handbook that it's not intended to chill employees' exercise of their rights, especially on policies like confidentiality policies. Sometimes will be, you don't mean it for it to be aggressive, but it could be read that way. So it's good to have those disclaimers in there. All right, so to finish up, we're going to talk about existing laws and deadlines. We'll talk about the new COVID regulations, which they've pared them down so much. We all ask why they haven't gotten rid of them, but this is what they're doing and they keep changing it. And then just a few reminders on your harassment training, CalSavers, and last but not least, of course, the overtime rules. So we'll start with COVID-related updates. AB 685 was the notice provision that required you to provide the written notice of a COVID exposure in the workplace to all of your employees within 24 hours. Technically, this expired on January 1st. You do have to keep records of all the notices you provided for 3 years. So anything you've provided since the start for 3 years, keep those, don't delete them. The issue is that under the Cal OSHA regulations, which are still in place, you do still have to provide written notice to all your close contacts within 1 business day of any exposure in the workplace. So it's a very similar requirement, and that didn't go away. So you do still have that. The Cal OSHA non-emergency regulations are still in place. These took effect last year on February 3rd, and they're set to remain in effect for 2 years, so until next February, so a year from now. You still have to comply with these regulations. They do update their FAQs pretty regularly on the DIR website. So if you Google Cal OSHA non-emergency reg FAQ, they'll pop up, and they do tell you at the bottom when they've updated them. So it's good to keep an eye on it because they do tend to make sort of out of the blue updates. You are also still required to maintain your COVID prevention plan, your CPP. So if you haven't updated that or looked at that in a while, good to look at it, see if it needs to be updated or changed. Mostly we're not seeing a lot of issues with people complaining about COVID. What we see is that someone will make a Cal OSHA complaint about something else. And then when Cal OSHA comes in, they'll say, oh, by the way, can we see your COVID prevention plan? And then if you don't have it, then you'll get dinged and there's a penalty. So we mostly see it in that situation. So you may think, oh, no one cares about COVID, it's fine, but you'll mostly it'll just get tacked on to something else that comes up. And that's what we've seen the most. So they did recently, just in January, mid-January, change some of the requirements. So there are updated face mask requirements for close contacts. So anyone who had close contact with someone with COVID, masks are now only recommended. So they used to be required. They're only recommended now for 10 days after the contact. It's still required that if someone has tested positive for COVID, they need to wear a mask around others for 10 days following the test or when their symptoms started. So if you have someone back at work before the 10 days, they should be wearing a mask. In the event of an outbreak or a major outbreak, you still have to provide masks, and some local ordinances still require it, but mainly for specific employers. So like healthcare facilities, if you go to the doctor, you might see it's still required, but most no like general public employers are required at this point. They also changed the outbreak definition. So the new outbreak definition requires at least 3 COVID cases within an exposed group during a 7-day period. It used to be 14 days. So the effect of this is the shortened period means you're less likely to have an outbreak, right? Because it's 7 days instead of 14 days. So I think that is helpful for a lot of employers. The infectious period definition has also changed. If someone has symptoms, so they've tested positive and they have symptoms, The infection period is just the 24 hours from the day that they started symptoms. So if you had symptoms today, this was your first day, it would only go back to yesterday when you're determining like who's a close contact. That's the infectious period. If you don't have symptoms, if someone just tests positive, no symptoms, there's no infectious period. So that also changes our exclusion periods, which this is the biggest change probably for employers. So if you have someone who has symptoms from the day of symptom onset, so let's say it's today, they have to be out of work for at least 24 hours. Then they can return after 1 day as long as they don't have a fever and their symptoms are mild or improving. So let's say someone had really mild, like sniffles, they test positive, they go home for full 24 hours, 2 days later, they're feeling generally fine, they don't have a fever, they can come back to work. They do need to wear a mask for that 10-day period from when they started, but you can have people come back to work. So that's a big change. There's no longer that 5 days. It's pretty fairly loose. Obviously, a lot of people will be feeling bad and may not come back to work that fast because they don't feel good and they want to stay home. But if they're feeling better, you can let them come back. If they don't have any symptoms, they just tested positive, there's no isolation period anymore. So if they're like, oh, I tested positive, but I feel fine, they could still come to work. They do need to wear a mask for 10 days, but they could be at work during that time. Obviously, as an employer, it's up to you if you want to have different rules, but these are the new regulations. This is the minimum of what you have to comply with. A reminder to do your harassment and abusive conduct training. This is required every 2 years. It's for all employers with 5 or more employees. Your supervisors, managers, they have to do at least 2 hours, and it's 1 hour for your non-supervisory employees. You can do this in person. You can have someone come do the training. The CRD does provide free online trainings on their website, and they offer over 10 languages for those, which is great. So if you need, especially if you're having trouble finding a training in another language for your employees, I would check there first because that's a really good resource. Reminder that if you have new employees hired or you promote someone to a supervisor when they previously were not, they have to complete the training within 6 months of the hire or promotion. If they provide evidence that they've done it within the last 2 years, like with a former employer, that's sufficient. But I would say this is a big one for our vineyard clients because you may have a lot of seasonal employees. What we recommend usually is just make the training part of their onboarding so that it's done. You don't have to think about it. If you try to do it within 6 months, you're going to forget because it's hard to remember these things. And they're probably watching videos on other stuff anyway. So it's a good way to just get it done quickly. CalSavers, this is just a reminder. This has already gone into place and most of the deadlines have passed unless you're a very small employer. But essentially, employers with 5 or more employees have to have some sort of private retirement plan, like a 401k for your employees, or you have to enroll in CalSavers so that employees can use the CalSavers program. All CalSavers is a state-run retirement savings program. There's no cost for you to participate in it. What you do is when you sign up, you'll put a payroll arrangement in place, and that'll require employees to contribute unless they opt out. If you do your own private plan, you don't have to do any of this. You're fine, you're compliant. The deadlines have passed, but if you still need to do it, it's good to check on that and get it done. If you're a small employer with 1 to 4 employees, you still have until December of next year to comply. So there's still a lot of time, but that is just a reminder not to forget that requirement. And then the change in agricultural overtime. So this has been going on for a few years now. If you are a larger employer with 26 or more employees, the overtime has already phased in. So your agricultural workers now get overtime at 8 hours a day and 40 hours a week, just like most other employers in the state. If you are a small employer, 25 or fewer employees, your phase-in is still happening. So this year, the overtime for small ag employers, so 25 or fewer agricultural employees, will be after 8.5 hours in a day and 45 hours in a week. Starting next year, January 1st, 2025, everyone in the state is going to be at 8 hours a day, 40 hours a week for overtime. So just something to keep in mind. I think everyone's aware of it because it's been going on for quite a few years now. But with very few exceptions. We will all be on the same overtime rule starting next year. All right. Any questions? It can be about any topic. We don't have to limit it.
That was great, Marissa. Really great job. It was like very clear and easy to understand, which is sometimes
Great.
difficult with this stuff. So
Yes, and we made it in time. So.
thank you for making it simple for us. Does anybody have any questions? If you want to either type them in the chat or unmute, that is just fine as well.
We can stop the share, so if anyone wants to pop in.
I had a question about posting new job descriptions
Oh, yeah.
for the position, and wanted to confirm that it's still required that you need to post the salary range on there. Is that correct?
Yes, yeah, so that started last year, and you do have to post the range. It's for all jobs, there's not really an exception. So you got to get the range. We have seen some people sort of change their job position so that they could have a variety of ranges at different levels, because some jobs you'll look at and you'll think, wow, this is quite a large range for this position, because you have more senior employees who've been doing it for a long time. So sometimes it's helpful to break it up into, let's say you have tasting room attendants, you can have like tasting room attendant 1, 2, 3, and have different levels, and those can have different ranges that are a little more, just seem, more of a reasonable range.
Absolutely. And that's required to be posted everywhere, right? Like on your website, on your LinkedIn posting, on your Indeed posting, on Wine Jobs.
Yeah, so if you use a third party like Indeed, you have to make sure it's included in that. Sometimes I've noticed those get missed a lot.
Yeah.
And they're not on there. When you look on LinkedIn, it's missing the range. So make sure you're checking those and see that the range is there, so you don't get penalized for something silly.
Yeah. Okay, great. And then we had a question, if our COVID practice is to stay out for 5 days after a positive test, are we obligated to pay an employee during those 5 days?
No, there's no longer any kind of COVID paid leave. Of course, if they have sick leave available, that is a valid paid sick leave reason. So if they ask to use their sick leave, they should be permitted to use it. Depending on your vacation policy may say whether they're allowed to use vacation time or not for that, and that would be up to them. Sick leave for sure. But there's no other like mandated requirement. I could see now that the rule has changed, you might get complaints from employees saying, well, I want to come back sooner. And Cal OSHA says I can, and I'd like to come back because I'm not making any money while I'm out.
Yeah.
And that there is some wiggle room in the law, because it says that, it's your symptoms have to be mild and improving. So there is some, what is mild? What does it mean that it's improved? Like there's still some lack of clarity there, but I think you're fine to have your own rule to protect your employees and protect everyone else from getting sick if that's what you want to do, but you're not obligated to pay them.
Okay, great, thank you. And then somebody's asking, what is the definition of an agricultural employee?
I don't have the formal definition like at just right here. I can look that up for you, but in general, it's going to be anything ag related. I think it's related back to the employer. I'd have to double check. It may be what wage order you're under. So if you're under wage order, gosh, off the top of my head, 8, or is the other one 4 or 3? There's 2 agricultural wage orders. If you are under one of those wage orders, I believe that's how they do it, that it's by wage order for the employer. So there's one where you're producing or harvesting any kind of agricultural product for yourself, like for your own use, so like a winery that has its own vineyard. And then there's also the other one, which is for anyone who does ag, sort of like harvesting, growing, any type of agricultural related task, where they then sell it. So like if you're only a vineyard or you are a farm labor contractor, so those have their own wage orders. So if you're under those 2, I believe that's how they define it. So I would look at what wage order you're under. You can have employees under different wage orders. So for if you're a vineyard and winery and you have tasting room employees, your tasting room employees are under a different wage order, and they would not be ag. So they're under the regular overtime rules.
Okay, right. Awesome, super helpful. Very
Yeah.
good. Any other?
Yeah, the
last-
wage orders will be sort of like not that applicable anymore because they're all going to be like identical now.
Yeah.
So we may eventually get rid of those in California. They're sort of a unique California thing. I haven't seen those in other states.
Yeah. Well, great. Well, it looks like we've exhausted our questions. So Marissa, thank you so much for joining us today. It was
Yeah,
a
of
great
course.
presentation, and we will send out the presentation as well as this recording to everybody that registered for the webinar. It'll also be available on the Yountville Chamber YouTube channel as well. So thank you all so much for joining us today. It was a pleasure to be with you. And thank you again, Marissa. We'll see you next time.
Yeah. Thank you, everyone. Have a great rest of